The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, everyone. This is Kristen Justice with Beyond Pay, and thank you so much for taking time out of your busy schedules to join us for today's compliance webinar. We have quite a few people still jumping on, so I'm going to give you about 30 more seconds to get settled in front of your monitor. Make sure that the presentation is utilizing your full screen and that the audio is coming through clear for you. All right, a few more people jumping on. Fantastic. We see a lot of current clients, people we haven't had the opportunity to speak with yet also jumping on. So we have a whole range of attendees, which we're excited to see. Okay, so we're going to go ahead and get going with today's compliance webinar. So this webinar is going to be quick. It's going to be about 25 to 30 minutes long, and the reason why is because we know everyone is extremely busy and over inundated with compliance updates and everything. So Jason Zaun is our Director of HR Services, and he is going to give you an overview of everything compliance, okay, in regards to the ACA, OSHA, and FLSA. So we are going to do a little Q&A session at the end of today's webinar, so hang on for that 25 to 30 minute presentation, and then we're going to open it up for a Q&A session. As we go through this webinar, it is live. Feel free to submit your questions in the little question chat box, and I'll make sure that we respond to them promptly or get back to them concluding today's webinar. So thank you again for joining. I'm going to turn it over to Jason at this point so we can go ahead and get it started.
Thank you, Kristen, and good afternoon, everyone. Today we are going to be talking about compliance issues, and kind of what we want to talk about today are a couple of different topics. So we want to talk about performance reviews, benefits and benefit notices, ACA updates. We're going to talk about the OSHA penalty increase that's coming up, FLSA proposed changes, and then some ongoing compliance. So when we talk about compliance, we kind of look at the whole year, and we kind of look at, all right, when do we do certain things throughout the year? So kind of the way I'm going to go through this is kind of a yearly snapshot. So typically I advise most of our clients that performance reviews should typically be done in the first quarter. So that should be typically wrapping up right about now, but if you didn't do it yet, that's okay. You know, and the benefit notices, we should have had those sent out, and we're going to go through the details of all of these kind of from a timeline standpoint. But then we also identified these other ongoing compliance issues, if you will, where it doesn't need to be done at a certain time, but it should be done at least yearly. So we're going to talk about those, and you know, really from an HR standpoint, as long as they're done yearly, it doesn't matter when they're done throughout the year. So one of the reasons we came up with this topic, this compliance topic, is a few months ago we had an FLSA webinar, which generated a lot of response, and most of it was because of the proposed changes that are being reviewed as we speak. So we want to talk about those, but we also want to talk about other compliance issues, not only for this current year, but just to prepare you for how to prepare your HR year. So that's really what we're going to talk about today. Okay. So the first thing I want to talk about is performance reviews. So a lot of companies think that, you know, I only have a couple employees, I really don't have to do employee performance reviews, and that's really the incorrect way to look at performance reviews. You should be conducting performance reviews whether you have 1 employee or 5,000 employees. And it's really not, for the management side, the company side, but it's also for the employee side. One of the major employee needs, when you look at the entire employee needs from an employee standpoint, they're looking for that feedback. So it's very, very important that you're giving them that feedback. And it is human nature to want to get better in everything that you do. So giving employees that feedback is going to allow them to increase their performance, which in turn should increase company performance. But a couple of best practices about performance reviews. We want to make sure that they're conducted for all employees on a regular basis. The expectations and responsibilities are clearly communicated. And then our systems for measuring performance are in place. So we want to make sure that we identify the exact measuring goal, what we're going to be measuring for each employee and each specific job. We want to accurately document We want to look at employee job descriptions, making sure that they were reviewed and updated at least annually. I know a lot of our clients that we work with, they have very dated job descriptions, so we really want to make sure that you're looking at those on an annual basis. And then you want to review the process and systems for measuring performance and treating employees equitably. You want to make sure that you have the same criteria outlined for at least all the jobs that are similar. So if you have customer service rep, you want to make sure that you're measuring performance of all customer service reps the same. So switching over to benefits, employee benefit plans, medical and retirement, you want to make sure that they're complying with all the requirements under federal and state law. So most recently ACA is going to have your requirements on the medical side, and then you want to make sure that from the retirement side that you're complying with all ERISA laws. Also some best practices, you want to review all of your plan documents, including the enrollment forms. Some enrollment forms you may need to revise based on some of the new laws, especially the ACA laws, just to make sure that they're accurate, consistent, and in compliance. And then summary plan descriptions. This is very commonly missed by a lot of our clients, and I'm assuming many other companies, but when you have a new enrollee in a plan, or your plan changes, you need to send out summary plan descriptions to every employee new in the plan or when that plan changes. So you typically have 90 days to get that out. So that's very important. We're beyond the 90 days right now, so if you did miss that is important to take care of right away. We also want to make sure employees are provided the required notices regarding COBRA, and this is whenever you have a new hire and they're eligible for benefits, we want to make sure that we're letting all of those employees, those new employees, know about COBRA. And just as a side note, it's not only if they cover their spouse on benefits, it's also required that you send the spouse a notice as well. So Affordable Care Act, most everyone knows that there were new dates that were published. So the 1095B and 1095C, which were originally due on February 1st, 2016, were just most recently due on March 31st. So hopefully you have all of those out to your employees. The next dates that you need to worry about is May 31st and June 30th. So the 1094B and 1095B, 1094C and 1095C were required on February 29th. Now they're required on May 31st. Okay, if you're filing electronically, you have until June 30th. Okay, so those are just some important dates to make note of and make sure that you're on target with those. Okay, switching over to OSHA. If you're required to keep an OSHA log, your OSHA log should now be posted. So February 1st through April 30th, that's the time frame where you need to have your OSHA log posted. Along with that, there are some proposed changes that will take effect on August 31st. So it's a minimum increase of 80% on violations. So serious violation fines are going from $7,000 per occurrence to $12,600. And then repeat violations are going from $70,000 to $126,000. So that's quite a big increase. So you really want to make sure that you're complying with all OSHA laws and you know, making sure that you handle violations and make sure that you don't have repeat violations for, you know, basically similar injuries that could have been avoided. So that's the biggest thing there. Okay, so let's talk about the FLSA overview. So on March 13th, 2014, President Obama proposed a memorandum to the Department of Labor to make changes to FLSA exempt status qualifications. So really the purpose was to update existing protections, address the changing nature of the workplace, and simplify the regulations to make it easier for employees and employers to understand and apply. Really, this is going to, it's estimated that 11 million employees are going to be impacted by this change. So currently, this new law is in the Office of Management and Budget as we speak. So it is expected to pass, and it is expected to to go into effect at some point within the next couple of months. Typically, when it does go into effect, you have 60 days from the date the rule is published in order to comply with the law. So I don't know if it's going to change or not, but right now we're anticipating that 60-day once the rule is published. So some of the major considerations. The major one is increasing the salary threshold from $23,660 per year to $50,440 per year. And what this means is that if you currently have a non-exempt employee, if you have an exempt employee making $35,000 a year, this new law, when it goes into effect, that employee will no longer be able to be exempt. They would automatically be considered salary non-exempt and eligible for overtime. So you can see that this is a huge deal, and it's going to, you know, potentially cost employers tens and thousands of dollars in order to comply with this law. The Department of Labor proposes to automatically raise the salary level as well. So basically, as inflation occurs, those salary levels will automatically increase. Based on the old law, there was no provision for it to automatically occur. So they would actually have to, you know, kind of go through what they're doing today to get everything passed. But in the future, as this rate is automatically going to increase based on inflation. And then the third major consideration is highly compensated employees will increase from $100,000 per year to $122,000 per year. So a couple tips on managing FLSA. So making sure HR and payroll work together to make sure that all the policies are aligned. We want to educate our managers and supervisors on best practices and policies, and also the consequences on cost of non-compliance. So the cost of non-compliance here is huge. You can't just simply say, well, I'm not going to make the change, because if you get audited, the fines are substantial. And then we want to educate and communicate to employees why the changes are taking place. So simply just making the change and not communicating to employees is probably not the right approach. You want to make sure that if somebody is now going to be considered salary non-exempt, you want to make sure that you communicate to them that, you know, the law has changed and now you're going to be salary non-exempt, and this is what your pay will be like moving forward. You know, making sure that they understand that anything over 40 would be time and a half. Okay, so we're going to talk a little bit about ongoing compliance considerations. So this would be things that need to be done on an annual basis, or at least should be done on an annual basis, but do not have to be done at certain times of the year. Typically, from an HR standpoint, if you are in HR, typically your first quarter is going to be your slowest quarter. So I usually like to recommend that we do these in the first quarter. You know, kind of second quarter, third quarter, you're preparing for benefits. So first quarter for a lot of HR people is the best time, but then again, that depends on your benefit plan year and things like that. So, but as long as you're tackling these on a yearly basis, I think everything will be fine. So, so you want to make sure that you're reviewing your employment applications. There's several new state laws. One of those is the ban the box question that employers ask on applications. So you really want to make sure that you're paying attention to your state laws and making sure that your application is in compliance. Written authorizations are obtained for background checks according to the Fair Credit Reporting Act. So you want to make sure that you have the correct language. If you actually have the authorization for background check on your application, you want to make sure that if there are any state-specific requirements, that you have them on your application, or if you have a separate authorization for background check, you want to make sure that you have that language spelled out for your state. Policies and procedures relating to drug testing, the use of arrest and conviction records, and other candidate information, you want to make sure that they're complying with federal and state law. Forms I-9, and for those that don't know, the actual current form is actually expired. 3/31/2016 was the expiration of the current I-9. and it has been extended, so it's not typically on your, it's not going to be on your form, but there is kind of an off-the-record type expiration date of 4/30/16. So currently there are some proposed changes to Form I-9, so it's still okay to use the one that expired on 3/31, but I'm thinking that by the end of this month there will be a new I-9. You want to make sure that you are using that new I-9 form. So new hire reporting requirements are satisfied in necessary tax forms. Usually on an annual basis, it's a good idea to make sure that you do have an I-9 for every new hire that you hired, and you have a tax form for every person that you hired. It's usually easier to do this if you do it on an annual basis. I mean, obviously you want to try to do this as soon as you hire somebody. In fact, the I-9 is required within 3 business days. But just to do an audit to really make sure that you do have everything and something wasn't misplaced, because of the cost of noncompliance, especially for the I-9 form, is quite large. And then you want to review your orientation onboarding program for welcoming new employees. Any new forms, you want to make sure that you update those, handbooks, things like that. So speaking of policies, procedures, make sure that they are in compliance with state and labor laws, especially pertaining to employee leave, equal employment opportunity, sexual harassment, worker safety, and other requirements. So you really want to make sure that you're paying attention to the state and federal law changes and making sure that you keep your handbook up to date. One of the biggest things that I see is employers coming to me and saying, all right, can you do a handbook for me? And obviously we do handbooks, but my first question is, when was the last time it was updated? And surprisingly, most of the clients say more than 3 years ago. So to really make sure that you're in compliance, you want to make sure that your handbook is in compliance. You know, if you ever end up in a lawsuit, they're going to look at your handbook, and if your handbook is out of date, you know, you're going to be out of luck on that one, unfortunately. So you want to make sure every employee is provided with that handbook and explains the company policies and procedures, but it's not only giving them the handbook, but it's also having them sign off, not necessarily that they read and agree with it, but that they have at least received the handbook. So that's a very important second step to the handbook. You want to make sure labor laws are posted and on display. So any time that you have a minimum wage increase, either federal or state, you want to make sure that you update your labor law or your labor law posters. And I know a lot of you get those envelopes in the mail that allow you to order, and it looks very official and it's from the government. Really the only time to replace your posters is when there is a change to a federal or state law. So typically for our Beyond Pay clients, we're sending this out to you to let you know that that there were changes that you need to order, and that's something you can certainly do through us. But those poster envelopes that you get, the sales envelopes, really don't need to do anything about that. You just need to really make sure that you have the correct poster, and if you ever need us to look at that, we certainly can do that for you as well. You want to make sure that procedures are in place for maintaining employee records and all files required by law. So you want to make sure that you have your purging records according to the requirements. You also want to make sure that you're storing your medical records and other confidential documents in a separate file. Most of the time when I do an on-site audit, HR audit, the biggest non-compliance issue I see is medical records in the file, and it's not necessarily for new employees. It's typically for those 15, 20-year employees. So you really want to make sure that you're going back through your records and auditing those records to make sure that there are no medical records in the employee file. You want to make sure that you go back as far as you can to the highest senior person that you have, and make sure those medical records are pulled and kept in a separate file. And the same goes for the I-9 form. You always want to make sure that the I-9 form is stored in a separate file as well. You want to make sure that employees are receiving necessary skills and training including safety and sexual harassment. There are a few states that do require sexual harassment training for managers, so you want to make sure that if you are in one of those states that you are completing that on an annual basis or whatever the state law says. And then finally, you want to make sure that human resources policies and procedures apply equally to all employees and are applied fairly and consistently. One of a best practice here is to really make sure that this administration of policies and procedures is done through a central person or department. Leaving it up to managers to decide how to administer policies and procedures always leaves room for error. So I usually recommend having a central department or one or a group of people who are administering the policies and procedures for the company. So moving on to employee pay requirements. So you want to make sure employees are properly classified, and this is going to be huge for FLSA. Job titles alone do not determine an employee's exempt or non-exempt status. A lot of employers think, oh, their title is manager, so I'm just going to call them an exempt employee, and unfortunately that does not work. You must justify that the job that the employee is doing is either exempt or non-exempt based on the job duties, not necessarily the title. You want to review all your pay practices, including the minimum wage and overtime compensation for compliance with both federal and state FLSA laws. And in fact, there are quite a few state laws that are more favorable to employees than the federal. You want to look at your employee pay periods to make sure that they are scheduled in accordance with state and state wage timing requirements. There are a few state laws that you must pay employees biweekly, so you want to make sure that you are paying them at least biweekly. And then pay and incentive programs, treating employees equitably, and decisions regarding promotions and merit raises are based on clear objective criteria. And this goes right back to the performance reviews, making sure that you have performance reviews for all of your employees will make decisions about promotions, merit increases a lot easier to decide. And then another one is independent contractors. A lot of employers have unfortunately made the bad decision of calling their employees independent contractors to avoid the ACA laws. So there is a very defined rule to kind of test to see if somebody is an independent contractor versus employee. So you really want to make sure that you are coding employees correctly and not just coding independent contractors to avoid offering benefit coverage. All right, so moving on to employee discipline and termination, you want to make sure that policies are in place for collecting keys and other company property. The best way to do this is really through an exit checklist or some type of termination checklist to really make sure that you're covering the same things for every employee that terminates. You want to make sure final paychecks are delivered at the time of termination. There are a few state laws that dictate when an employee who is terminated must be paid. For instance, in California, you must pay, if the employee gave 72 hours notice, you must pay the employee their last pay on their last day of work. And if you don't, you're basically going to be paying for every day that you're late. So it's very important that you coordinate that. If you have 72 hours notice, you have to get them the check on their last day of work. You also want to make sure that neutral references confirming former employee's position held, and dates of employment are available upon request. So you want to make sure you do that with a company policy. And then review all discipline, investigation, and termination procedures for compliance. So you really want to make sure that the way that you're disciplining and terminating employees is in compliance with all federal and state laws. A couple more things on employee discipline and termination. So making sure all of your policies and procedures for handling employee disciplinary actions are clearly, clearly defined, written, and communicated. So at each step of your progressive disciplinary process, you want to make sure that you're documenting everything. It's going to help you in the long run. All matters involving employee discipline are accurately documented. And then termination meetings are conducted to inform employees of the termination. So a really good best practice in a termination meeting is to conduct an exit interview to really identify if there is any risk associated with with the employee potentially suing the organization for things that you could have known about. And the best way to uncover that is through that exit interview. A summary of the meeting and any related information prepared and placed in the employee's file. So you want to document that conversation and put it in their personnel file. And then departing employees are provided with a written summary of accrued benefits. This is something that is missed with some of our clients. You really want to make sure that you're outlining exactly what's going to happen for the employee. When are they going to be paid? What's going to happen with their 401k? What's going to happen with their health coverage? It's very, very important that that does take place. Okay, so the last thing I want to talk about is technology. So everything that we talked about today is basically, most of it can be done through technology. There are, in fact, recently I just saw a commercial. It was a car commercial, but it was a couple people were asked to pick the tool that they want to use. It was a power saw and a hand saw. So everyone picked the power saw, and the reason they picked the power saw is because it was a better tool to use for the job. It was quicker, it was more efficient. So that's kind of the way that I view technology and being able to help you with human resources related items. So you always want to pick the better tool, and when there is a tool available, you want to make sure that you're using it when you can. So our time and attendance technology is able to track and manage overtime hours. BeyondPay has an ACA manager to help you with that, benefits administration, COBRA, onboarding, pretty much everything we talked about today. We have a system in place to be able to help you with that. And then scheduling technology to build and plan schedules in regards to business needs and employee needs. So all of that we have in place and is available to you, and certainly if you need more information on that, you can contact Kristen. But also those things that you kind of need a human touch to. We also have a different division of BeyondPay, which is our HR Business Partner Services Department, and we are able to help you with that as well. So anything that you kind of cannot use technology for on the HR side, we're able to help you with that as well. So with that, I will turn it over to Kristen.
All right, awesome webinar, Jason. Thank you so much. You covered a lot of ground in less than 30 minutes. That's fantastic. So everyone on the line, we're going to open it up for the Q&A session, but right before we do that, I wanted to just let you know that we are going to be following up with a compliance calendar for you as a resource, which is really exciting because I know Jason went through quite a few deadlines, dates, and need-to-know items, and so we're going to provide you with that resource as a follow-up. We're also going to make sure to provide you with a copy of the slide deck and a recording of today's webinar. So we did have some really great questions come through, so we can only get to 3 today. So first one that we have here is, can you define what you mean by medical records? So when you were talking about needing to have medical records on file, Jason, can you talk more specifically about what you meant by that?
Yeah, so it's basically anything related to medical. So for instance, it could be an enrollment form for medical. You just want to make sure that if it has anything to do with medical, that you store that in a separate file. It could be medical benefits, it could be health related, it needs to be stored in a separate file. So hopefully that answers your question.
Perfect, thank you. Another question here is, if a spouse is not on a benefit plan, do they still have to receive the initial COBRA notice, or is that only for the employee of the company that's on the medical plan?
It's only for, well, the COBRA notice is for anyone who's covered on benefits. So if the employee signs up the spouse for benefits, then the spouse needs to receive the COBRA notice as well.
Got it. Okay, perfect. And then last question that we have here is, how did you say BeyondPay can help with ACA compliance?
So we have an ACA manager, which we are able to turn on for our clients, which basically is tracking employee hours through the BeyondPay system, and we are able to track to determine if somebody is full-time or part-time. So that's kind of how we manage the ongoing ACA compliance, but also we're able to do the 1094s, 1095s for you and your employees. So at the end of the year, we're able to run those reports so that you can submit those for your requirements.
Perfect. Okay, I know we have a bunch more questions coming through, guys, but thank you for those. We'll make sure to follow up with you individually with more specific questions. And then, of course, like I said, we are going to be sending you a compliance calendar as a resource. We're going to follow up with a slide deck, and then we also are going to give you a recording of today's webinar. So thank you all for taking time to join us. We hope you found this to be very informative, and we'll be following up with you soon to talk more around your company and ways Beyond Pay can help. So have a great Wednesday afternoon, and thank you again for your time.